In Module 3, we looked at primarily the statutory law in Canada that provides a regulation of the employment relationship in Canada. Uh, Employment needs to be regulated largely because employers cannot be trusted to treat employees fairly. They cannot be trusted to do the right thing with respect to workers. And so over generations, decades and hundreds of years, employment law has developed to protect employees from the arbitrary and unilateral decision making of employers and to provide minimal conduct relative to minimal working conditions for employees. And this module will expand on the framework of employment law by considering another source of employment law called wrongful dismissal. In Canada, if an employee feels they've been dismissed wrongfully, they can sue their former employer in a court of law, civil court, for wrongful dismissal damages. The basic understanding in Canada is that any employee can be terminated at any time, but the employer has to provide reasonable notice of termination, which can range all the way up to 24 months or even longer, depending on a number of factors. So in this module, we'll expand on the regulation of the employment relationship, some of it related to the law, and some of it related to voluntary things that employers can undertake to improve the relationship. So what is employee relations? In contrast to labor relations, in this module, we're focused on, in this area of law and regulation, we're focused on the individual employment relationship, not the collective relationship as represented by unions, for example, in Canada. So how what we're really considering is how the relationship operates in practice. And why is that important? Well, because getting employee relations right has different significance than having an effective recruitment or training strategy. It's likely more important than many of the HR functional areas. Workplace climate, for instance, for employee relations may enhance management's credibility or undermine it when other HR functions are carried out. When employees perceive that the essence of the relationship is sound, that they will be treated fairly, they're much more likely to accept other management decisions, even if some of those decisions go against the employee's interests. So effective employee relations can result in greater trust between the employer and employees and a positive climate in which discussion of performance and other issues can take place. To continue with that discussion of employment relations, think about your own experience. Do you feel better about participation in a team or group when you have a good relationship with those in authority, when you feel valued by the group? Are you more confident about expressing your views and that your views will be taken into account when decisions are made? Do you remember, for instance, times you felt you were treated badly? In contrast, how about times you felt very good about your job or your employer? How does that contrast with the times you were treated badly? Do you remember in the places you worked lawsuits or other complaints about the employer, or perhaps in other organizations? Virtually every day I scan the news, I find examples of employees being treated badly by their employers. In other words, the employment relationship is defective. The employer is untrustworthy virtually every day. And in fact, HR management, the whole course is about employee relations in that effective decision making in all areas of human resource management can improve the state of employee relations. However, in this module, we're going to focus on communication, discipline, dismissal as a form of discipline, as well as employee rights and employee engagement or involvement. So there are a number of ways that good employee relations can be important to the organization, why it should be important to top management. First of all, good employee relations can improve productivity. poor relationships can have a significant impact, on a negative impact on productivity. It undermines employees' ability to do their job and their attitude toward their work and their employer. Implementation of organizational strategies can benefit from good employee relations. Why would an employee care about goals and strategies if they're not being treated fairly? So employees can provide their commitment when they're treated, when they know they'll be treated fairly and with respect. It can reduce employment costs. Employers who have poor employee relations, the working conditions are less than adequate. They quite often have high turnover, which can increase their employment costs. With increased turnover, we have to recruit, hire, train more employees. Just as an example, in a typical call center, we might see a turnover rate of somewhere between 100 and 200%. That means, just to give you an example, if we have 100 employees in our workplace call center, if we have a turnover rate of 200%, that means every year we have to hire 200 new employees. We only employ 100, but we have to hire 200 every year, and that means the recruitment, selection, training, and so on that has to be done to bring them up to a productive level. It can also reduce things like absenteeism and lateness and other dysfunctional attitudes and behaviors in the workplace. It can help employees grow and develop. It's good. It's good for people. It helps employees to achieve their personal goals. It improves morale, loyalty, and productivity. And yet so many organizations have absolutely no idea how to improve employee relations. One of the cornerstones of good employment relations is communication with employees from the top to the bottom of the organization and back up again. So you notice in this table that on one side I've got examples of downward communication, and on the other side I've got examples of upward communication. So downward would be communication that's coming from management, top management, down through the ranks all the way to the front line of the organization. Some examples, providing information about aspects of the organization, plans for the organization, why we're issuing shares, etc., why we're expanding and things like that. We can use in-house publications to inform employees about what's going on. Information booklets. So, for instance, when a new employee joins the organization, is there a handbook with the policies and practices related to the employee so that they're fully aware before they start their job of what job requirements are? We can use occasional bulletins or pre-recorded messages, electronic communication, of course. Many organizations have what are called intranet networks. So it's kind of like the internet, only it's within the organization, so that employees can access information about their relationship with the employer or plans of the employer or any number of items on a timely basis. We can also just simply, have lots of town halls, make announcements on a regular basis about things that are going on. Open book management refers to making sure that employees understand the condition of the organization, financial and otherwise, so that they understand, employees will appreciate when decisions are made if that information has been shared with them and they can see the need for particular decisions. But not sharing that information, you're just setting yourself up for failure. In terms of upward communication, first of all, you have to make sure that if you are collecting information from the bottom to the top of the organization, you have to make sure that management will be influenced by the information. Will management take it seriously? If you give feedback to management and they do nothing about your addressing your feedback, sooner or later you'll stop giving them feedback. You'll stop looking for them to make decisions that take your concerns into account, and you'll start looking for another job, or you'll start withdrawing from your engagement with your job, and so on. Again, there's electronic communication and grapevines. Is there a drop box? Is there a suggestion box? Is there a way to communicate with top management easily and effectively? Are there complaint procedures? Again, same idea. We're going to talk about one particular kind of complaint procedure here today. Are there meetings to share information? The suggestion box I already mentioned. And one that I want to talk about, another idea that I want to talk about a little bit, is the job satisfaction or attitude survey, job attitude survey. Today, employers who think they're in the know will try to call these things employee engagement surveys, but they're nothing more than what in my time we called job satisfaction surveys. It's an opportunity for, or should be used as an opportunity by employers to collect information about what makes employees dissatisfied with their work. I'll show you an example in just a second. This is a very small sample of a job satisfaction survey. Typically, a job satisfaction survey might have 100 or more of these items that would cover topics like the relationship with management, supervisors, satisfaction with pay and benefits, satisfaction with job opportunities, promotion opportunities, training opportunities, the workplace climate itself, and a whole range of issues that might undermine the employment relationship. If you're management, you want to collect this information because there may be areas where you can make substantive change that will influence the kind of experience and attitude that employees will have to relative to the employer and to management. Good attitudes, good satisfaction will lead to more acceptance of management's attempts to make effective decisions in the workplace that will be accepted and implemented and so on. So let me draw your attention to a couple of these items just to give you a sample of what's going on here. Number 3, for instance, this company's wage rates are competitive with those of other companies. Later on in the module on employee compensation or pay, we'll talk about a concept called external equity. It's the extent to which people feel fairly treated, or fairly compensated, I should say, compared to employees doing similar work in other organizations. And so if I'm actually, when I worked at the Nova Scotia Teachers Union many moons ago, some teachers, and not a large number, but a significant number, were dissatisfied with their pay relative to other teachers in Canada. So I said, oh, that's interesting. Maybe I should do a little background checking on this to discover why they might be dissatisfied. What I discovered was that teachers in Nova Scotia at that time, which is, my gosh, that's like almost 30 years ago now, they were well paid compared to teachers in Prince Edward Island and New Brunswick, significantly better paid than those teachers, and Newfoundland as well. They were comparably paid to teachers in Calgary, places like Calgary and Saskatchewan and Manitoba. The only place where they were significantly underpaid compared to the teachers in that jurisdiction was in Ontario. And if you think about the cost of living in Southern Ontario, of course they're going to be paid more. So when I confronted some of these teachers on, it seemed that they had a misunderstanding about their relative rate of pay. Their relative rate of pay actually seemed to be quite positive compared to other jurisdictions. So if you're the employer, you probably want to educate your members, your employees about how well they're being paid compared to others. There's another item, number 5. I understand the various fringe benefits the company offers, and Almost as important as compensation are and I don't know why it's called fringe benefits here. It probably shouldn't be, but because they're anything but fringe. Some of the benefits that we can earn as employees, like pension, for instance, are very important. They're part of our compensation package. In fact, a pension plan is considered deferred compensation or deferred wages or deferred salary, whatever the situation is. And so, some of these benefits can be very important to the employee. So calling them fringe benefits is misleading, I think. Let me give you an example from my own situation here at Acadia. When I first arrived here 14 years ago, almost 14 years ago, the pension plan for faculty, your professors, was in deep trouble. We were underfunded, and within a few years, the university came looking to us to make up the difference. But what had happened was that they had withheld their contributions that we had negotiated with them, and they were allowed to withhold these contributions according to Nova Scotia law. And so they cut back on their contributions during the times when the market was very positive and growing quickly. And then when the markets turned the other way, we found suddenly that our pension plan was underfunded by millions of dollars. And it was because the university, our management, our employer had failed to continue making contributions to the plan like they had promised. And then they came looking to us to make up the difference. And there was a period of time when I was paying, I think, somewhere around $400 a month to make up this difference. And I was here 5 or 6 years and still earning the same kind of money that I had earned when I first started at the university 4 or 5 years before, because they were withdrawing or deducting even more from my pay. So if they'd asked me at that time, I would have given them a piece of I did give them a piece of my mind. How did we solve that? We actually took the pension plan. Eventually, we were able to find a provincially mandated pension plan run professionally outside of the university. And the university now is required to make regular payments. They cannot make reduced payments. They have to make the payments that are required month after month to ensure the plan is properly financed. And so we had to take the pension plan away from the university because management could not be trusted with something as basic and simple as our pension plan. It was quite disgusting, actually. I hope you can hear the disgust in my voice. Another thing I wanted to say about number 3 too is that, or 3 I should say, also, is that that's external equity. We could also ask questions about internal equity. Do you feel fairly compensated compared to other employees? And I bet you some employees at Acadia might feel underpaid, and I'm sure they do. Not necessarily professors, but other staff at Acadia probably feel underpaid compared to others. Another question we could ask is, are you satisfied with your take-home pay? Another thing I discovered on moving back from my job in Ontario was that at the rate of pay that I was earning, and I got paid roughly the same at Acadia as my former employer, I was paying $5,000 more a year in provincial income taxes. So my take-home pay was about $400 a month less than I was taking home in Ontario because of the taxation in the two provinces. So my satisfaction with my take-home pay here at Acadia, also I would have been far more dissatisfied than I was at the school I was teaching at before. Over the 14 years of employment at Acadia, that would represent about $70,000 of hard cash, stuff that I could have used for home improvements, for a really nice car, for my pension plan, and on and on and on. So these are things that we should be concerned about as employers, because maybe there's something we can do to improve satisfaction. So we can talk about the rights of both management and employees as well And again, I think I've already stated this, but let me restate it. In Canada, or maybe restate it in a different way, in Canada, management has the right to run the business and make necessary decisions for successful achievement of organizational objectives. In particular, the employer has the right within certain limits to decide the composition of its workforce. Now, at Acadia, for instance, we are unionized, as are almost every faculty in Canada. There are very few universities left who are not unionized. That's an additional limitation on the ability of the employer to manage the composition of the workforce. We put certain restrictions in place in our collective agreement with the university so that they have to employ a certain minimum level of professors. They can't get away with well, they do, but they can't get away with as many part-time or contract workers as they might otherwise. That's especially important in a university, and something that both administration and students sometimes don't understand. When we put these requirements in our contracts, it doesn't benefit me because I already have a job with good security, but it protects the quality of the education that you might expect. If we don't have a certain number of well-qualified professors, we should no longer consider ourselves a university. We're barely even a college if we let the ratio of professors fall below a certain level. However, that's the basic law in Canada. The employer has the right to determine the composition of the workforce within certain limits. Employees have certain rights as well, like the right to a safe and harassment-free workplace, the right to fair and ethical treatment, which is quite often ignored by employers. They should have the right to due process. In the law, again, we do have the right to good faith bargaining and good faith treatment, which is essentially the employer should not be misrepresenting themselves. They should be forthcoming. As an example, some of you might want to look at the most recent emails from the university about the bargaining situation here at Acadia. The last one they sent out was a web of lies, misrepresentations, and not what I would consider good faith bargaining. In fact, and going directly to students to influence students and faculty is actually against the law in Nova Scotia. And here the management is just going ahead and doing it anyway. Employees also have statutory rights like protection from discrimination, the right to privacy, and of course the right to safe working conditions. And employees have contractual rights. So if I wasn't unionized, I would have some kind of contract with the university, and the contract would have to honor the terms of that contract, or I would sue them in a court of law. Because we're unionized, we have a different way of keeping management honest. We have an arbitration system rather than a court system. Yeah. So from an employee's perspective, perceived unfairness may result from decision making of all sorts, such as discipline, or seniority issues in promotion or transfer or layoffs, job evaluations, unfair job evaluations, work arrangements that are, where there's continual change perhaps, overuse of overtime, withholding vacation or holiday benefits, poor compensation or incentives or benefits. So many organizations who are not unionized have opted to offer something similar to what unionized workplaces have. In a unionized workplace, there is a grievance process where complaints by either side, management or worker, can be made and resolved. But in non-union workplaces, typically you're not going to find these grievance processes. But some organizations, recognizing the importance of fair treatment to employee productivity and so on, and the cost of their doing business, these employers recognize that how important it is to be seen to actually make fair decisions and to be seen to be making fair decisions. And so they put in place what might be referred to as guaranteed fair treatment programs, or more specifically, a non-union grievance system, sometimes referred to as a NUGS. And that really communicates what it is. It's a grievance system, which we would normally expect in a unionized workplace, but it's implemented in a non-unionized workplace, recognizing how important it is to make sure that employees feel fairly treated. It's formal. It should be highly publicized. And employees should be able to appeal on a wide range of eligible issues. One example, I believe this might still be in your textbook, but some companies, larger companies like FedEx, have a guaranteed fair treatment program. IBM employs an open door program, and so on. These employers recognize the importance of engagement, disclosure, and fair treatment. So this is a major topic in this particular module. How do you discipline employees effectively? And just assume for the moment that discipline is required. There are many workplaces where discipline may not be required at all, and a disciplinary program might in fact be counterproductive. And for one, I'm thinking of a university. Imagine a place where you're employing, and we do need a disciplinary program here, but imagine the overuse of discipline among faculty. These are people, my colleagues, are people with, anywhere from 6 to 8 to 10 to even 12 years of formal education. How do you think they would feel about being disciplined for what they might consider to be very minor issues? One of the problems, again, I'll use Acadia as an example. One of the problems is the university really doesn't know how to discipline faculty. And so we have had problems with certain faculty over the years and certain professors over the years. And the university has let problems with these professors become really bad problems. Instead of dealing with them early, they let these disciplinary issues fester until it gets to a point where it's very disruptive to the workplace. We actually had an example several years ago, I guess it's probably 5 or 6 years ago now, where a professor in psychology actually was really doing some problematic things both related to his colleagues in the psychology department, but also among his students. And the university unfortunately failed to act early on to communicate to this individual how inappropriate his behavior was, and then it got down to a point where the only option was to fire him, and it put both the management of the university and the union in a difficult place, because the union had a legal duty to represent, we call it a duty of fair representation. We had a duty to represent the interests of this employee, even though we recognized how inappropriate and unproductive his behavior was, and we knew that something had to be done. But we also had the legal responsibility to make sure he was treated fairly in this process. The university could have done something much earlier to help with this. So anyway, we have a number of different ways of dealing with discipline in order to encourage compliance with the organization's standards. The first is what we refer to as preventive discipline. And this is actually, this may not sound all that understandable, but preventive discipline, I would argue, is really good policy institute it before the fact. So I mentioned earlier how important a handbook, an employee handbook might be, because it lays out the rules that the employee must follow in order to maintain the organization's standards. If you don't have those standards communicated effectively before the employee starts their job and then on a regular basis while they're working with your organization, it's difficult to then implement discipline after the fact. So having these policies in place in advance is a way of communicating that prevents bad performance or performance below standard or behavior that is inappropriate in the workplace. So very important to have strong policy statements on, and it depends on the workplace what that means. Like I can imagine a workplace where this may sound a little silly, but one of the rules of the workplace is you show up at the designated hour of the start of your shift, or drinking is not allowed on company premises. I know that sounds probably a little ridiculous to some of you, but there are workplaces where you need to be explicit. The employee needs to know what is acceptable and what is not. And it depends on the workplace, but it can be as simple as that. So what happens if preventive discipline doesn't do the trick? Then you take corrective action, corrective discipline. So corrective discipline is usually a penalty that follows a rule infraction. And so you're going to find out in a second about progressive, what we refer to as progressive discipline. The usual way to deal with disciplinary issues before they escalate, before they become too serious, is to provide a verbal warning to an employee. And if they repeat that behavior, a written warning, and then so on. You escalate the penalties or increase the penalties for each repeat of the rule infraction. And so, but in any event, what you're doing is you're attempting to correct the inappropriate behavior and communicate to the employee how important it is or why it's important to meet particular standards, and that they are going to be evaluated against those standards. And if they don't meet those standards, in the end, the employer has to be prepared to communicate that the employee's job may be in jeopardy if they continue to fail to meet these standards. So this is all part of a progressive disciplinary system, but it involves corrective discipline to correct the inappropriate behavior. Another important idea in discipline in the workplace is the idea of due process. So again, an employer should think carefully about what rules they want to put in place to not only rules of performance and conduct, but also rules of how an employee's interests will be represented. So I mentioned earlier the idea of a non-union grievance system for complaints by employees if they feel treated badly. Due process is essentially a commitment to following proper rules and procedures for discipline or for grievance, and it gives the employees the opportunity to respond. In particular, it gives the employees opportunity to respond to any allegations made against them. So a typical due process system should include the necessity of a full investigation, making decisions, particularly making decisions around an employee, their future, and disciplinary issues can be seen as unfair if the employer is working from incomplete or inaccurate understanding of the situation. So an investigation that is generally confidential and effective, thorough, unbiased, is very important to be seen as being fair. And it also, in addition to being seen as being fair, it also ensures that the employer is going to make an effective decision. Because if the employer does not have the full facts available to it, does not understand the context of the situation that might be involved, they're not going to be making effective decisions. So not only does it undermine the employee's trust and sense of fairness, it undermines the effectiveness of the organization's management as well. So fully investigate, provide an unbiased hearing, and an opportunity to have the employee speak their truth about what happened. And be represented, if possible, or accompanied in that process as well. So I mentioned progressive discipline on the previous slide, and this is the use of stronger and stronger penalties and warnings for repeated offenses. So it's essentially a legal requirement in Canada, in employment contract law, that an employee will understand before they're dismissed, they will understand that their behavior is problematic, that it doesn't meet standards, and that it could lead to the employee being disciplined or even dismissed. The employee really must understand that their job is in jeopardy. And so a progressive disciplinary policy gives both the employer and the employee an opportunity to respond to inappropriate behavior or conduct or performance on a timely basis without overreacting, and giving both sides an opportunity to understand what they're misunderstanding, what they're missing in the relationship. Is it support? Is it training? Is it a acknowledgement of the standards that are necessary for good performance, and so on? And so you can see how the penalties increase in severity as the offenses or infractions continue. And one sort of general advice for discipline is sometimes we refer to the hot stove rule. Make sure you, if the employee is seen to be doing something inappropriate, make sure they understand. So another way to think about discipline is it positive? Is it presented in a way that is productive or positive? So positive discipline takes a problem-solving or counseling approach. When we see the employee perhaps not meeting performance standards or behaving in a way that is inappropriate, we can take an approach that sees the behavior as a problem to be addressed, to be solved. And so in doing that, we can try to have the employee also acknowledge that their performance or their behavior is problematic, that they're responsible for this behavior, and then help us to understand, help the management, that is, to understand why this might be happening. Is there something that the management can do to help the employee to overcome whatever the problem is? Let me give you an example, because I know this is difficult to understand probably at some points, but every once in a while I'll see an example of suddenly there's a story about an employee, and the employer just suddenly out of the blue discovers that the employee has to work 10 kilometers to work and then 10 kilometers home after their shift, and because the employer just found out that after the employee being late for a shift, that they're unable to get to work on a timely basis because they have no transportation, and if the conditions are poor. And I think I've probably seen items like this in the news several times over 2 or 3 decades at least, and it's always a kind of like, holy crap. And good on the employer for recognizing, for asking the questions, for investigating, and for discovering that the employee's trying to do the best job they are, and they're making enormous efforts to perform their job effectively. But we wouldn't know that if the employee or the employer didn't take a positive approach, a problem-solving approach, to try to determine why that employee might be having difficulties. And I can probably come up with a whole range of different issues that could be cropping up in any particular workplace. But we're never going to know if we just lash out at the employee instead of trying to understand what the problem might be. And so with positive discipline, we have the employee accept that a problem exists. We try to find a way to deal with the problem, an effective, productive way. We might want to document the employee's commitment to fixing the problem, or providing some resources ourselves to help the employee, and then we need to follow up. So that's a problem-solving or positive disciplinary approach. So what happens after you've taken corrective disciplinary action, probably progressive disciplinary action, and the employee is still not getting it for some reason? When does the action of the employee rise to the level of a discipline, a dismissal, a form of discipline that's required because the employee seems to be bent on repudiating the employment contract? So dismissal is that last step in the progressive disciplinary policy. However, many employers in Canada don't know what the employee's rights are, and so many employees are dismissed illegally, without just cause and without reasonable notice of termination. So in Canada, I'll just read from my slide here for a second. In Canada, any employee is entitled to reasonable notice of termination or severance in lieu of notice, unless the employer has just and sufficient cause for dismissal. So the employer, from the employer's perspective, in general, you can terminate anybody you want, but you have to provide reasonable notice of termination. And that can range up to 24 months in Canada or even longer, unless you have just and sufficient cause. And in my own experience, employers quite often don't have just and sufficient cause. Now, I think I mentioned earlier, employers still have the right to determine the composition of their workforce within certain limits. So in Canada, one of the limits on this, on the employer's ability to act unilaterally, is you can determine the composition of your workforce, but anybody that you want to terminate, you have to provide reasonable notice, unless, of course, they provide just cause for their termination. So, so it's protection for the employee provided by what we call common law of wrongful dismissal. So there's statutory law, that's what I talked about in the last module. In this module, wrongful dismissal law comes from an area of law called common law. So common law is determined in the courts. It's a law that builds up over time from the decisions of the courts themselves. So there isn't a statute or a code, or there isn't some written document passed in, or in one of our legislatures, in one of our governing bodies, that tells you shouldn't do this. We know about this law because we study the decisions of the courts, and the courts themselves study each other's decisions so they can make consistent decisions. That's why it's called common law, because they're operating under common understandings of principles of, in this case, employment law. And the courts, by the way, are far more generous with their remedies where employees have been wrongfully dismissed. As I mentioned, reasonable notice periods, which is essentially the damages awarded by the courts in cases where employees have been wrongfully or illegally dismissed. And they can range all the way up to 24 months and even more. The employment standards, or sometimes referred to, like in Nova Scotia, the employment standards are referred to in a document called the Labor Standards Act. It doesn't refer to unionized employees, it refers to non-union employees in Nova Scotia. In Ontario, the relevant document is the Employment Standards Act. And a lot of employees think that that's their protection in the workplace. But these pieces of legislation are considered minimum standards only. Minimum. Like minimum wages, as an example. They're the foundation on which pay or other standards go up from there. Employers can offer a lot more than the minimum, but they can't offer less, or they should not, or they will find themselves in court. And a wrongful dismissal. So let's say my employer terminates me. I'm in a non-union workplace, and my employer terminates me, and I believe that it was wrongful or unfair. I can sue my employer in civil court, and basically the court, as long as I've made what's called a prima facie case, the court will hear the facts, the arguments from both sides, from the employer and the employee's side, and their decision will center on two key determinations. Was I terminated for just and sufficient cause? And that is a high standard for the employer to meet. And if not, to what length of notice should I be entitled? And so this is another way of stating what I've already stated, which is that any employee can be terminated in Canada with reasonable notice of termination. So I know that's just the basics of the law. It gets quite a bit more convoluted, I guess is the word. And that's actually what we study in my course called Employment Relations. We spend about half of the course working on wrongful dismissal law. So on the face of it, it sounds like the employee has a great deal of protection in Canada. But in spite of that, for non-union employees who have been unfairly terminated, your remedies or recourse are limited to the labor or employment standards tribunals that I just mentioned, associated with statute law in each jurisdiction, but they enforce only minimum standards. So a lot of employees don't understand that that's the minimum that they're entitled to. Or they can go to the courts to get a better remedy or recourse to wrongful dismissal. But the problem with the court system is that it's expensive. In most cases, you would have to hire a lawyer. That can cost money, and it can take up to about 2 years to get a date in court. So imagine you're an employee who's not earning a lot anyway. Are you going to be able to endure for 2 years to have your case heard in court? Not many people are. There is an alternative that is quite interesting, and that is every jurisdiction in Canada has, in addition to the sort of mainstream court system, they also have what's called small claims court. And this is an ideal place. If you're a waged worker, hourly waged worker, and you might only be working 15 or 20 hours a week, and your employer treats you unfairly, you can go to small claims court. One of the benefits of small claims is that it costs very little to file a claim, and the employer is still required to show up, and they bear the burden of proof that they terminated you with just cause, or that they provide a reasonable notice. And you don't even have to have a lawyer. Another benefit is you don't even have to have a lawyer. If the employer doesn't show up for an appointed hearing in a small claims court, the judgment will, I think, pretty much automatically go against them, and it's up to the employer to respond. They carry the burden of proof. They have to make their case. And so you can get a judgment entered against your former employer with very little cost. So for a lot of employees, instead of going to the employment standards tribunals, they should go to small claims court. They might get a much better and more sympathetic hearing. In addition, a lot of people don't understand they may have multiple avenues other than the courts as well, such as human rights complaints and the human rights tribunal. So we can't simultaneously go to undertake all of these remedies, but we can make a choice that might be more favorable to the employee. So pop quiz, what is wrongful dismissal? Can you name the components of wrongful dismissal? The answer, a wrongful dismissal in law in Canada is a dismissal without just cause or a dismissal in which the employer did not provide reasonable notice of termination. In either case, I can sue my employer for wrongful dismissal. So what is just cause for dismissal? So it includes any act by the employee that could have serious negative consequences for the organization. So for example, incompetent work performance. So we usually refer to either incompetence of the employee or poor performance of the employee. It could also refer to employee misconduct. Things like theft, fraud, and dishonesty. Those are fairly serious allegations against the employee. There are other forms of misconduct as well, harassment, assault, insubordination, disobedience, and so on and so on. There are quite a list of potential just cause arguments that an employer can make. The employer has to be, well, a couple of things about, let me start with incompetence. The problem with alleging incompetence of an employee is that not only is the employer putting the employee in the hot seat, in a sense, to prove or demonstrate that they weren't incompetent, but the employer also has to demonstrate that they were competent because the employer is also responsible for managing performance. And there are certain basic things that an employer must do to support the employee, to let the employee know that what good performance looks like, and to provide the training and other supports to ensure they can meet those standards. They have to make sure that the standards are consistent among, to that employee and to other employees as well, and so on. So it's a high standard. It's not easy to demonstrate. And then in terms of theft, fraud, or dishonesty, for example, if the employer alleges theft, for instance, that is a very serious allegation. And if they get it wrong, if they haven't investigated properly, and if they've thrown allegations around about the employee stealing from them or committing fraud, these are very serious allegations. If they get it wrong, the courts will not be kind to them, and the employee will have avenues to sue the employer for damages. So this table is from the work I did for my doctoral dissertation. I examined about 165 wrongful dismissal cases. I did what's called a content analysis of the cases, and I examined each case for the presence of these factors or these variables, which you see on the left-hand side of the table. And so what you'll see here is the statistical significance of each of these factors. And so look to the far right-hand column of the table, and the little squiggles there beside the numbers indicate statistical significance of each of the factors. And so you can see, and by the way, this is what this model does is predict the probability of an employee victory in a wrongful dismissal case. And as I said, I examined a large number of cases. And so the statistical significance will tell us the factors that the courts considered important enough to sway their decision or to influence their decision about who should win, the employee or the employer. So again, look at that right-hand column. If the employer makes an involuntary change to the conditions of work for the employee that wasn't contemplated or wasn't agreed to by the employee, that can lead to a 5% increase in the employee's probability of victory. If the employee performs satisfactorily before the dismissal, that can increase the probability of the employee's victory by 9%. If the employer failed to use progressive discipline, I've talked about progressive discipline before. If they use dismissal before they've used other lesser forms of discipline, that will increase the employee's probability of victory by 6%. If they fail to provide procedural justice, so a hearing, an investigation, a candid explanation of what the employee did wrong, and so on. There are a number of issues there. That can lead to a 5% increase of the employee's victory. If the employer failed to warn the employee that what they were doing could lead to dismissal or a discipline or dismissal, or failed to communicate to the employee that their job was in jeopardy, and so please change your conduct. That could lead to more than 15% increase in the employee's probability of victory. And the biggest factor of all is the employers frequently fail to communicate performance standards effectively. And where that was present in the court cases, it led to a more than 20% increase in the employee's likelihood of victory. So these are key things that I discovered statistically that the courts recommend that managers do when determining when to discipline or dismiss an employee. So I mentioned that it's difficult for an employer to generate a case against an employee, and it's at least partly because the employer themselves will be put under the spotlight, examined for their role in failing to manage performance. And so what are some of the things that employers should do to demonstrate that they did their part in managing performance? So did they set reasonable and objective performance standards? And were those standards applied consistently and communicated clearly? Did they document failure to meet those standards? Did they provide warnings to the employee? And is there evidence that those warnings were delivered effectively? First of all, that the job of the employee is in jeopardy if standards are not met. And also, very important, what is required to improve? It's not enough to tell your employee that their performance is below standard. What must they do to improve? You should give the employee a reasonable amount of time to improve their performance. You should be able to provide evidence that the employee has had adequate training, feedback, and other forms of support. Were you helping them to be better employees? You can see how many employers can fail to do these things. And so they're just as, they have just as much responsibility for poor performance or more as the employee does. So another little pop quiz. What is the difference between reasonable notice and severance? So reasonable notice of termination is a period of time, and it varies from about 2 weeks to 24 months or even more, a period of time considered reasonable in which to locate a new job of similar stature and responsibility as the job that the employee is leaving. The employer may require, this is called working notice, the employee may be required to work until the end of the notice period. But I would think that most employers would let the employee go at the time they're being told their job is ending. So if, just as an example, if my employer came to me today and said, you have 3 months, I'm giving you 3 months notice that your your position with us is coming to an end, generally speaking, most employers would say, please pack up your desk and leave today, at the end of the day, maybe, or right away. Sometimes they want you right out of the building. And why the difference? Well, in certain workplaces, it makes sense to have an employee work till the end of the notice period because there may be still productive work left for them to do, things that are particular to them, and it's in maybe a professional workplace where the employee is relatively trustworthy and so on and so forth. But in a lot of workplaces, the employer won't take that chance, and they'll actually, it's actually kind of disgusting. They will usher the employee out of the building as soon as possible, treating all employees as if they suddenly became criminals or potential criminals. It's kind of disgusting, but from an employer perspective, they don't want the employee to have the opportunity to get up to mischief in the workplace. I've had some experience with this myself. I worked actually for the Nova Scotia Teachers Union, about 3 decades ago, and I was downsized along with several other employees after about 3 years with the Teachers Union, and I was their research director, and but they wanted me to work till the end of my notice period, which was 3 months, which was specified in a written contract I had with the employer, and as long as I had work to do, they wanted me to continue. But I had already completed any substantive projects that I was working on at that time, and I had other things of my own to work on. So I told them, I really don't have anything left substantive to do. So if you don't mind, I'll take my leave now. And they weren't unhappy with that. And so I left with 3 months notice. During that 3-month period, I continued to receive my pay and benefits for that period. And then it ended at the end of those 3 months. Another way, though, that notice period is handled is to create a severance package. So instead of salary continuation, as I received, the 3 months would be bundled into, of pay and benefits would be bundled into a lump sum that could be paid. And so the important thing to determine is what is reasonable notice. And I didn't feel too bad about 3 months because I'd only been with them for a little under 3 years, and 3 months was about reasonable for 3 years of service at that point. If I'd been there longer, I probably, I might have, taken up, gotten legal help with that, hired a lawyer and so on, but I didn't. And or some combination. So quite often employees will be terminated with some combination of salary continuance and maybe some kind of lump sum payment. It depends on what the employer, how the employer wants to handle it. So what is reasonable notice? Well, I think I mentioned this earlier in an earlier slide, but it's the length of time considered reasonable to find comparable work to replace the work you've been terminated from. And we consider certain factors. There are in the case law, there are literally dozens, more than 100 factors that have been used in various cases over the decades, but it usually comes down to about 5 or 6 important factors, such as the employee's age. The length of service is probably the most important of the factors. Their salary or status in the organization. Status refers to where they might fit in the hierarchy of the organization. So somebody in the executive suite has a higher status than somebody, a clerk, let's say, in a low-level job. So salary is sometimes used as a stand-in for status. But anyway, in any event, where they fit in the hierarchy is considered. Occupational status, labor market conditions. in practice, did I already talk? I already talked about that, I guess. In practice, there are some other conditions that might also be used as well. So yeah, not recently, but in the last 20 years since Wallace, the Wallace decision in 1997, Supreme Court of Canada decision, there have also been these things called augmented damages, and that can be added by the courts if the employer acts in bad faith in the manner of dismissal. So you need to treat your employee with dignity and respect even after you've terminated them, or you can end up in trouble in court having to pay additional damages for the manner of dismissal. Just some examples of what reasonable notice periods might look like. In 2000, there was a case here in Nova Scotia involving a store manager named Day who worked for Walmart. He actually managed the Walmart store that's just a couple blocks from where I live here in Dartmouth. The store no longer exists at that location, but he got from a jury 29 months of reasonable notice. So that's over 2 years of salary and benefits paid to him, primarily because the employer, Walmart, was acted in bad faith toward the store manager, accused him of dishonesty in a disproportional response to the actions of the store manager. Another case where the reasonable notice period was quite long is the Wallace versus United Grain Growers case from 1997, another Supreme Court of Canada decision. And Wallace got 24 months of reasonable notice period from that decision from the courts. So this is a table of the results from my doctoral dissertation a number of years ago. I examined about 105 reasonable notice cases, so wrongful dismissal cases in which reasonable notice was awarded to the employee by the courts. And so what I'm looking for are some of the factors that influence the length of reasonable notice period in that group of 105 cases. And you can see on the left-hand side the factors that I examined, and on the right-hand side the statistical results. What was significant is asterisked, or the other thing I used was a cross of some sort. I'm not sure what they call that cross, but in both cases they indicate statistical significance. And so one thing is interesting is that the Wallace decision in 1997 had what is a relatively dramatic effect on all reasonable notice periods, it seems, in that in general the reasonable notice periods increased by about 2 months per case after the case was heard. So the Wallace decision seemed to change judges' attitudes toward wrongful dismissal somewhat, and the length of reasonable notice periods. They were more favorably inclined toward employees after the Wallace decision. And I have some theories about that, but I'll discuss some of that with you in the subsequent slides here. There's also a relationship between the vulnerability of the employee in the termination and whether the employer took advantage of that vulnerability. And so where the courts find that the employee was treated unfairly in the manner of dismissal, they were made more vulnerable by the manner of dismissal, that can result in an increase in reasonable notice periods of about 3 months. In addition, we know, for instance, that tenure is a very important determinant of reasonable notice period. There's a very strong link between the length of service of the employee and the reasonable notice period. In my model, it's about 1/3 of a month for every year of service. So about 7 months for about 20 years of service. Large employers are expected to pay more in reasonable notice, and there may be 2 different reasons for that. One is that large employers will tend to have greater resources to be able to pay reasonable notice periods, longer reasonable notice periods. But it also may be a penalty against large employers because they're more likely to have HR practitioners employed in their organization, and so they should not be making mistakes, dismissing employees illegally or wrongfully. And so maybe that's an added penalty added to the large employer's reasonable notice period. Occupational status also could add as much as 5 months for more serious or senior employees. And being induced to leave, as Wallace was, can add up to 4 months to the reasonable notice period. So some other examples of reasonable notice period in wrongful dismissal cases. McKinley, he was a manager who won 26 months of reasonable notice, more than 2 years. Patterson got 18 months of reasonable notice. Jasnock won 14 months reasonable notice. Typically in clerical and unskilled labor, we might see 3.5 or 4 months notice period, maybe a little more than that, but not a lot more. Management and executive level could be 10 months or more. Skilled in sales might be 7.5 months. Professional, similar, 5 to 7 to 8 months, and so on. And I'm just giving estimates. A couple of interesting quotes from the cases that I've already been referring to in Wallace versus United Grain Growers in 1997. This is a quote from Justice Iacobucci. He was one of the 9 justices hearing this case on the Supreme Court of Canada, and he wrote the decision for the other justices. So he says in his reasoning, the essence of the employment relationship is that the employee and employer are in an unequal bargaining relationship, and that the employee is in a vulnerable position. So it's a firm principle in Canada that employees are the vulnerable party in the contract relationship in Canada. It is the employer who has the bargaining power in almost every case. Not every case, because there are some cases where an employee may have significant power in the relationship, but in almost all employment relationships, it's the employer who has the most power, bargaining power. In addition, in that case, Wallace, they really set out a theory or a framework for understanding the nature of the employment relationship in Canada. And they also said the manner of dismissal can lead to additional damages, especially if these are intangible damages, so-called Wallace damages. Today, we might refer to them most commonly as augmented damages that come about as a result of tangible and intangible damages in the manner of dismissal. Another case that's important for our understanding of the case law today is McKinley versus BC Tel. And the principle that came out of this particular case is one of proportionality. The discipline should be in proportion to the seriousness of the misconduct or poor performance of the employee. You cannot use a blanket policy of, dishonesty is automatic dismissal. What was the dishonesty for? How serious was the dishonesty? And how would we respond proportionally? Again, another reason why progressive discipline is so important.